Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine Barker, a civil litigator with over 20 years of experience and a personal mentor, dedicated to guiding new attorneys through the challenging yet rewarding world of the legal practice. Every Sunday, we'll tackle those dreaded Sunday Scaries together. This podcast is here to demystify the practice of law and provide you with actionable tips and guidance. Whether it's mastering time management, developing effective legal negotiation skills, or finding your own worth and value in this demanding legal profession, we've got you covered. In each episode, I'll share insights from my 2 decades in the field, answer your burning questions, and bring in special guests who are experts in the various areas of the legal profession. My goal is to equip you with the tools you need and the confidence you need to face the weeks ahead and advance in your legal career. So grab a cup of coffee, take a deep breath, and join me every Sunday as we conquer the anxieties and uncertainties of the legal profession together. Let's turn those Sunday Scaries into stepping stones towards your success. Thanks for tuning in. Let's get started. Did you know that less than 3% of all cases actually go to a trial verdict? That means around 97% of all cases resolve either by dismissal or settlement. Whether you're taking a case all the way through trial or you're negotiating a settlement, just like a house, it's only as good as the foundation it's built on. Today, we're going to start a 4-part series outlining the step-by-step process of taking a case from start to finish. Handling a civil case involves well-defined steps. Each are crucial in ensuring a thorough and effective representation of your client. As an associate, you're going to be asked to do a lot of the heavy lifting, especially at the beginning. This might be interviewing witnesses, drafting discovery, doing legal research. Without having the experience of actually gone through a case, either through settlement or through trial, sometimes it's hard to understand the importance of each step. I'm going to break down each of these steps in kind of the 4 main important phases. That's going to be your initial handling, your discovery plan, and then depending on if your case gets settled, your settlement strategy, or if it's actually going to go to trial, your trial prep. The first phase is the initial evaluation. And this is broken down again into a couple of different key steps. But the first initial step, that initial contact, I like to do that within the first 24 hours of receiving a new file. First, and some of this stuff's going to probably be done by your partner, but it's important as the associate for you to know what steps they are and when they need to get done. So the first thing is going to be staffing. Staffing and your rates. The rates are probably going to be set by your partner, and that's going to be an agreement between the partner and the client. But it's important for you to know who's being staffed on a file. Is it you and the partner? Is it you, a partner, and a senior counsel? Is there a paralegal involved? And a lot of clients have requirements as to who can and cannot bill on their files. This is particularly important when it comes to insurance companies, because they usually have strict requirements about approved timekeepers. So make sure you know who's staffed on any file. Next, you're going to want to print out your court docket and then calendar any deadlines. You need to ensure that all important deadlines have been calendared. This is your case now. So you want to treat it as if you are handling this from start to finish. And what's one thing you don't want to miss when you're handling a case? That's an important deadline. Next, you're going to want to make sure that you're set up for any e-filing. So most courts now have requirements for e-file and serve. There's a number of different companies out there. Case Anywhere is one, e-file and serve. Some courts actually have their own. But you want to make sure that you've researched whatever jurisdiction you're in, whatever court you filed in, and that you're set up and using the appropriate e-file and serve. Next, you're going to want to make sure that a pleading caption and proof of service has been created. Again, the caption is really important. Once the caption has been created and accepted by the court, it can never be changed. So you want to make sure that when you receive a new case, your caption is accurate and it's exactly what's been approved by the court. And then your proof of service, this is making sure that everyone who's in the case who requires to be served with any documentation is getting served, either by e-service or by hard mail, depending on what jurisdiction you're in. I also like to set up a case information sheet. For me, this is a document that has all of the essential information that I need about a case in one spot. For example, the case name. Now, usually this is going to be plaintiff versus the names of the defendants. And sometimes that can be a little confusing, especially if your client is a cross defendant or if the matter is in pre litigation. The key is to be consistent, though, and use a universal name and be case specific in that naming. So if it is pre-litigation, and perhaps maybe it's a project, so you want to make sure that you're naming it and utilizing, a project-specific case. And then if it is in litigation, you want to make sure that you're using plaintiff versus defendant. And then if your client is actually a cross defendant, you might want to put their name in parentheses so that when you utilize this on a subject line for an email, it's got the case name, plaintiff and defendant, in parentheses, client, and then your client's name. You want to, if your firm has an internal filing system, make sure that you include that in your case information sheet. Again, it's a one-stop shop document that's going to provide all that essential information. So if you get on a call or you need to look something up, it's one document you can pull up. Now it's got the case name and it's got your internal file number. Also, if you're working for insurance companies, a lot of insurance defense out there, the claim number is essential for your insurance company clients. That's how they identify cases. They don't identify them by the name of the case or even the case number that's been filed with the court. They certainly don't identify it by your internal numbering system. What they identify it by is their claim number. I am vigilant in my subject line. If I'm emailing an insurance client, the very first thing on that subject line is claim number, and there's their claim number. So it's a key piece of information that you should include in your case information sheet. Speaking of insurance clients, and really for any client, a lot of them have billing guidelines. These are pre-printed, pre-approved guidelines that they send out to their attorneys at the beginning of a case. So you'll want to make sure that you know what those guidelines are and that you're abiding by them. Each carrier, each client has their own set of of their guidelines, how they want cases to be handled, how they want billing to be done. It's just important for you as the associate to know if your client has billing guidelines and what they are. Again, the case information sheet is a great place for you to just drop like a hyperlink into that document that's going to link you to those billing guidelines and those case handling guidelines so that they're right there at your fingertips. Who is your client contact? This is another really important thing. And again, if you're doing insurance work, you might have two. You're probably going to have two. One's going to be your claims handler and one's going to be your insured. But even if you're not doing insurance defense work or any sort of insurance work, you're at least going to have a client. So it's important that you put down who your client is, their contact information, their phone number, their email address, how they like to be, how they like to communicate. Do they like phone calls? Do they like emails? Do they like you to send things hard copy? Again, all this information included in your case information sheet. It'll be that one-stop shop for you to go look for any information that you need. And then finally, I like to include when I received the file because for me, that's a triggering deadline. So as soon as I receive a file, I've got internal guidelines that me and my team abide by, which is, within the first 24 hours, somebody calls the client to let them know, hey, so sorry, you've been sued, but don't worry, I've been retained as your attorney. Reaching out to opposing counsel. So when I'm going to provide a initial report and initial budget to my client. So I like to put in whatever the date was, because that's when things start rolling for me. Okay, so the initial handling. So within the first 24 hours, within the first day of getting a new file, go sit down and talk to your partner, shoot them an email and find out who's going to be staffed, what the billing guidelines are, who needs to be copied, copied by client or people within the office. When a case is assigned to you, treat it as if it's your own, as if you're going to be handling the day-to-day aspects of it. When you take ownership of a file, your partner takes notice of you. So things like making sure that calendaring is being done, who's going to be copied on things, you're going to be in charge of those day-to-day handling. A tip from me, I like to set up a weekly meeting with my secretary or my case assistant. We've created a system on who's going to be saving documents to the file, how clients are going to be copied on emails or reports that are going out. If I set up these systems ahead of time, I don't have to give instructions every single time I need a complaint filed, every time I have a report that goes to the client. I set these systems up ahead of time. And then also really important in those weekly meetings with your case assistant or with your secretary is you're going over the calendar. What to do this week? What hearings do I have coming up? Do I need coverage? Really important to start creating that early rapport with your secretary. Now, when I say that you need to be making sure these things are getting done, I don't necessarily mean you personally. So we talked about the 4Ds before: do, delegate, delay, delete. Do you have to do it, or is it something that you could delegate to your secretary, to a case assistant, to a legal assistant, and set up a system for you guys so that you are ensuring that everything's getting done, but you don't necessarily have to be the one that's checking the docket every week or filing things to an e-filing system. Once you have all of the key deadlines and everything calendared, to make an impression on your partner, send them an email with all of those key deadlines and pertinent dates that are coming up. And then make sure that your secretary's calendared them both for you and for your partner. I would also email your team, whoever it is that you're going to be working with. So once you've talked to the partner and you know who's going to be staffed, if it's you and a senior counsel, just you and the partner, you, a senior counsel, a paralegal, email them the billing guidelines for your client. Again, that's going to score you some brownie points, and it's going to give the impression to your partner that you're on top of your files. And then finally, you're going to want to make sure that your initial case evaluation deadline is filed. I usually calendar mine for 30 days after I receive a file. Some clients have different deadlines. Some want you to have an initial strategy call with them first. Some want the reports within 45 days or 60 days. I like to go with 30 because I like to be a little bit early. I hate for my clients to have to ask me where an evaluation is. Also, some really important documents that you should ask to be prepared as soon as you get a new file. We talked about the caption. You want to double check and make sure that everything is correct. You want your proof of service. You want to make sure that it's e-service, or if you potentially have somebody on the other side. There are some dinosaurs still out there who like everything to be hard mailed to them as well. If they won't agree to e-service, or if your jurisdiction doesn't require e-service, make sure that's clear in the proof of service that you save on your system, so that you've got that right at your fingertips. You know what kind of service is required. I also like to ask that shells be created for my pleading and my discovery. And then I have a master shell caption, and I never change that document. So in my case file, I'll have master shell caption, and that'll be the caption for my pleading. When I go to create a new, say a demur or a motion to strike, or I go to propound discovery, I take that master caption and then I save a new copy of the new document. That way, that master caption is always updated. So it'll have the most up-to-date information. So if my judge changes, I'll ask my secretary to go in and update the master caption with the new judge and the new department. If a motion for change of venue has occurred, I'll ask my secretary, I'll go in and I'll change that caption to update to the new venue. I might go from being in Los Angeles County Superior Court to now I'm in San Diego County Superior Court. So I'll need to make sure that my master caption's been updated so that I don't later on go use an old caption that's got all the wrong information in it. So if you've got a master caption, that'll ensure that all of it stays updated and you're always using the most up-to-date information. A budget. Most clients are going to ask you to provide them with a budget, particularly if you're working for insurance. So it's really important at the beginning you take a couple of minutes to think about your case. What direction is it going in? What is the amount in controversy? Am I going to have to take expert depositions? Is this just kind of plaintiff defendant? Let's propound some written discovery, take a couple of depositions. If that's the case, make sure that's reflected in the budget, so it doesn't look like you're taking 25 depositions for a case that's valued at $50,000 and there's really only two people that you care what they have to say in deposition. So spend a little bit of time really thinking about your case, where it's going, how it's going to get to resolution, if it's going to go all the way through trial, and then put that down in your budget. Some initial letters that I like to send out right at the beginning of a case. So immediately, I'm going to send a letter to whoever assigned me the case, whatever client sent it to me. Your partner's likely going to do this, but it's always a good idea for you to know that case comes in, you're going to send out an acknowledgement letter. Thanks so much for the file. Sometimes if I'm asked to do this or if your partner asked to do this, I like to copy my secretary so then my client knows who my secretary is. Again, we're doing an introduction thing here. So we're making sure that everybody knows who's working on this file, so that if they can't get a hold of me, they now have my secretary's information and they can get a hold of her. I also like to send a letter to opposing counsel. In addition to sending a letter to opposing counsel, introducing myself, asking them if they will agree to e-service. So now I just have to send them an email as opposed to dropping things in the mail. Sometimes I'll ask for a demand as well. If the case has been going on for a while, I'll probably ask them for what dates do we have going up? Are there any depositions set? But in addition to sending that letter to opposing counsel, introducing yourself, pick up the phone. Pick up the phone and call opposing counsel. I cannot tell you how many times opposing counsel's never called me. I've tried to talk to them. All we've never had a phone-to-phone conversation or a face-to-face conversation. You can learn a lot about somebody, particularly your opposing counsel, just by picking up the phone and calling them. I also like in that initial phone call to ask them for a demand. Hey, what does your client really want? And if you're on the plaintiff side, it's a really good time to kind of cut through some of the red tape and get right to the meat of your case and let opposing counsel and let your defense counsel know what it is that your client really wants. Sometimes just that initial conversation can shortcut a lot of unnecessary litigation and get a case to resolution as quickly as possible. And as we've talked about before, it's the one thing clients want to do. They want to resolve cases. They don't want to be in litigation. They're not in the business of litigating. They're in the business of whatever their underlying business is, whether it's construction, it's their work for a school district. If it's an auto accident case, maybe they were just driving their kids to school. They want out of this case. So the quicker you can do that for them, the better for your client. And then again, you look like a rock star to your partner. Next, something really, really important is that initial client call. So you'll want to call your client and interview them. Gather all of the information that you can about what happened, their insurance history, who are potential witnesses, what documents do they have? This is really a fact gathering opportunity for you. And as the associate, it's likely going to fall to you to kind of do that initial investigation. So you can set up a template for yourself of questions that you want to ask your client when you get on the phone with them. But some key ones that you're going to want to ask is, tell me all the facts. Tell me what happened. Give me your side of the story. You're going to want to gather their insurance history, because if you could potentially tender this to an insurance company, your client's going to appreciate the fact that you're trying to find them coverage somewhere. And then potential risk transfer. Are there other people you should be tendering to? If you've got a property management company and the issue is habitability claims, one of the questions you can ask them is, who owns the property? So that you can then tender the defense to the property owner. You're going to want to know what documents they have. Communications. Did they communicate by email or text messages? You're going to need to get those text messages, because really what you're doing, you're recreating the entire incident kind of behind the scenes. So those are all some really important information that you'll need to get from your client. Okay, and finally, our final step in that initial case handling is you're going to want to write a report now. You're going to want to report to your client all of your initial fact gathering. Maybe you talked to some witnesses. Definitely you interviewed your client. You've evaluated all of the pleadings. And now you're going to put all of that information together and you're going to provide them with a report. Most clients have some sort of reporting guidelines that they want you to follow. Some key things that you're going to want to include in your initial report is you're going to want to research your judge. Is this judge a defense-friendly judge? Is he a plaintiff-friendly judge? What did they do before they were appointed to the bench? Were they appointed to the bench, or did they run for office? You can do some just research online to find out some information about them. You can ask around to other colleagues, see if they've ever worked with this judge before. Some jurisdictions like California have civil code. We have civil code 170.6, which basically says that we can challenge a judge for any reason or no reason at all. We don't even have to tell the judge what the reason is. So if you've done your research on the judge and you find out that this is not going to be a good judge for your client, based upon what you know about the case, you might want to challenge the judge. Check your jurisdiction, find out if you've got one of those, if that's a tool for you. You're also going to want to do some research on opposing counsel. Are they difficult to work with? Read some Yelp reviews about them. Clients are going to tell you a lot about how they interact with their clients. Go to their website. Do you have a construction case and the person, typically does, plaintiff personal injury? Are they going to know kind of the ins and outs of that particular area of law? Obviously, like I said, you're going to interview your client. You're going to get all of that information, their case history, potential risk transfer, if you're going to tender to insurance. You're going to want to review all of the pleadings and then provide a summary to your client on the status of the pleadings. Are you going to answer the complaint? Are you going to file a complaint? What affirmative defenses do you have? What causes of action do you have? Is there a potential for a cross complaint? Are you going to challenge the pleadings? And what other parties are involved? And again, do your research on the other parties as well. I also like to do a section in my initial report on the facts. Give them the background facts. And these reports do not have to be, 20 pages long. You want to be thorough but concise. Understand that your client, if they're an insurance company, they've got a lot of files on their desk. They don't have time to read 20 pages of, just regurgitation of the law to them. Be concise. And if they're not, if they are a business or an individual, they probably don't understand all of that legalese. So you want to make sure that you're speaking in your tone of your letter is understandable and professional. You don't want to use phrases like, "Yeah, he fled the scene and the people called the cops." You don't want to use phrases like that. But you do want to make sure that you want to make sure you're being professional, but at the same time, you want to make sure that you are understandable. Kind of lay out for them all of the causes of action, the elements, potential defenses, what a discovery plan you think you need to put into place. We'll be talking about discovery plans on next week's episode, so be sure to tune in for that. And then finally, I like to end my initial reports with next steps. Here's what I recommend we do next. You want to always be advancing your case and letting your client know, I'm trying to resolve this for you. Either I'm pushing it towards trial because that's what I recommend, you and your partner recommend they do, or we're trying to resolve this case for you. So always put in there, kind of next steps. Here's what to expect in the next 30 days. And then really, really important, once that initial report is drafted, it's over to your partner. They've had opportunities to work with you on any revisions. The budget is done. You get all of that out to the client. Calendar your next report. Make sure that you're reporting. And I recommend at least every 30 days. so that your client is always up to speed. The two number one things clients will complain about with respect to their attorneys is lack of communication, so not responding to them, and overbilling. We'll talk about billing in another episode. Thanks so much for tuning in. Hope this was helpful for you. Be sure to tune in next week where we are going to be tackling discovery plans. Have a great day. Enjoy your Sunday.